Okay, good afternoon, everyone. So working language is English. Everyone is okay? Okay, my name is Nataliya PETROVA. I'm working as a deputy director for USAID funded project New Justice. And I was invited kindly by our colleagues from IRF to moderate this session. And it's my honor and my pleasure. And we have very respected people on our panel discussion. And so maybe, hopefully, more colleagues will join us to hear the experience of 3 countries involved in the judicial reform area. Just before I will invite first speaker to the floor, I would like just to give few comments, actually, as a moderator, that why it is important, why we gathering in the special session, why judicial reform is on the agenda of every actually country, particularly new democracy country. You know, the state and government has a positive obligations to fix the judicial system to serve the people. And I like very much the quote from Alexander Hamilton, who was one of the founding fathers in US, who said the most appreciate people in the country is a well-functioned, efficient judicial system. So before voting, or even when voting for the parliament, etc., citizens putting their hope that the government and parliament will invest to provide the service, and especially in the justice area. So that's why judicial reform everywhere is a high priority. And we are here, be listening in this afternoon, early afternoon session, the experience of 3 countries involved with different perspectives, but with the same past, right? Who came from the Soviet Union with all the challenges we're all facing. And I believe that each country experience will enrich each of us, and we can the luxury to listen to lessons learned, not to repeat the mistakes if any mistakes are in place. So with this, I welcome your attention, and I welcome the first speaker to start the session, and it's my colleague, Mykhailo ZHERNAKOV. Mykhailo is the chairman of the board. He's chairing the DEJURE Foundation. And particularly important to have Mykhailo among us because he's former judge. He had some first-hand experience being a judge in Ukrainian judiciary system. So welcome.
Thank you very much, Nataliya. Thank you very much, Renaissance Foundation, for this opportunity to be here and to be able to speak to you today. I'll try to be brief. However, there's really a lot of things that's worth discussing, especially when it comes to rule of law reforms in Eastern Partnership countries. It's always hard to compare. I think I'm not in a position to really compare the 3 because I'm not as knowledgeable in reforms in Moldova and Georgia as I am in Ukrainian ones. However, I have this luxury to know a little bit, to be able to dig a little bit into it, also because thanks to Renaissance Foundation, we had the project where we actually compared the judicial governance in the 3 countries. And here, I'm very happy to be in the same panel with Ilie, who worked as an expert on this project and who delivered brilliant work, and we were able to deduct really important results from it. In a nutshell, yes, we're very similar countries in a sense that we are all Eastern Partnership countries. We're the countries that signed the association agreement are implementing the association agreement with the European Union. And we are, unfortunately, also all 3 of us were or are at the moment subject to Russian aggression, and territory of all 3 countries is to a certain extent occupied by Russia or Russian-backed forces. So a lot unites us, and there's very similar problems that we face, that's for sure. We also try to tackle them in a very, sometimes very similar manner. We try to make our we have the same problems inside the judiciary, right? Unfortunately, it's still corruption, it's political dependence, it's the lack of accountability, and we, for many years of our independence now, almost 30, are trying to tackle these problems by different judicial reforms. Last but not least, these reforms were aimed at obviously making judiciary more independent, more publicly accountable, but also in different ways trying to renew the judiciary, trying to bring in new blood into the system that would really change the system from within. Also, it is important to note that reforms in these countries were very often, or for the most part, in many cases, driven by two factors. One external, it's our international partners, mostly the European Union, to which we want to belong. Talking about Ukraine, it's entrenched in our constitution now. We also know that the other, Moldova and Georgia also have their aspirations. So it's in many ways EU-driven or international community-driven, but it's also very much civil society-driven. Civil society is making a lot in each country to achieve those reforms. Very often these reforms are not because of, but rather despite the political will of the governments at the time, that it seems to me at least that also in many cases what is similar are trying to show progress, trying to kind of tick the box, but at the same time still trying to retain control over the judiciary in many ways. That obviously results in very mixed results. Sorry for the we show progress, we report the progress on paper, but in many cases, because of the lack of political will to really make judiciary independent, there's little result in reality. How to tackle this? What are the real problems? One that we really can't change only through the democratic processes, and that requires 4 or 5 year electoral cycles, sometimes less, but usually that much. It's the political reasoning, but there's also a very important technical detail. It's the judicial governance. We see that on a technical level, it always comes down to who decides upon judicial career. And here I must say a very unpopular thing now, but as much as we like, as much as we recognize the input and the role of the EU and the international community in really making Ukraine's and other countries' judiciary better, there are certain things where the international standards are not exactly applicable, which was, by the way, recently recognized by the Venice Commission in its interim opinion about Moldovan reform. And we're now expecting the Venice Commission's opinion on our Bill 1008, which is now Law 193-9 or 4. I have to remember the new number. It's been 1008 too long. Which we're expecting very much. But the Venice Commission said in the countries that have, unfortunately, have these post-Soviet background, where judiciary never was independent, the application of the standard of majority of judges elected by judges, of the self-governance standard, very often results in a paradox, where judiciary, not being independent itself, gets the constitutional guarantees of independence of the highest level. And that results in people getting to the judicial governance bodies that are not of highest integrity and professionalism, that issue decisions both not in the best interest of the reform of the people, but also not in the very best interest of the judges, let's be honest. So, but that's good news. And this is something that we found researching judicial governance in Ukraine, Moldova, and Georgia. But there's good news. There's a way out of it, it seems. And it's being tested right now in Albania. It's also tested. It's been tested in Ukraine, and it will be tested right now in Moldova, as I understand too. We're hopefully very much looking to your experience as well, and what you have to say, Ilie, about this. The international element or direct international involvement in judicial governance, at least for the time being of the reform, because from what we saw, the selection to the anti-corruption court, where we had an independent international panel of the experts delegated by the European Union, by the Council of Europe, by other very reputable European and international institutions really makes a difference. It was compared day and night to the selection to the Supreme Court. With all due respect to Judge BUSHCHENKO here, there are agents of change inside the Supreme Court, like himself, who are really progressive, who really move it forward, but unfortunately we don't see there are a majority or a decisive vote inside the institution. We see that the competition and the selection of the judges to the anti-corruption court, where we had such an international panel, at the very least did not let go through a single tainted candidate about whom the civil society or the international community had severe reservations. So that tells us that we have similar problems. We have been trying similar approaches, made similar mistakes, but we also now, it seems at least, are looking at the very similar ways out, and we're really looking forward to implementing and scaling these success stories, and hopefully that this, at least for the time being, when we have to effectively change the system, be the way forward. And I think I'll stop here and be very happy to listen to colleagues' experience and of course answer all the questions if such arise. Thank you.
Thank you, Pana Mykhailo. Thank you very much. And I just would like, before passing mic to another speaker, I would like to say this right. That's correct, that the global approach local damages, right? We know this article written by our Slovak Global Solution Local Damages, but also we, all of us, all our countries, we do know that there is like a developed by international community, international organizations. Excuse me. Thank you very much. Okay, it's better. Thank you. Developed a set of the standards. Those standards are like guidance for each country, which is transit from the totalitarian form of state to the democratic one. And of course, those standards are guiding principles everyone has to respect. Like, we are talking here about institutional independence of the judiciary and personal independence of the judges. I do not know to what extent our foreign colleagues present here are aware, but before 2016, Ukraine has not a full set of the independence guarantee for the judges. So only with the introduction of the constitutional changes back to June 2016, the judges got life appointment. They got limited scope of the immunity. There is a number of issues which was really, there is a immunity, professional immunity fixed with in the constitution. A number of the stuff which absolutely guided the development in that or other direction. So with this, I invite Justice Arkadiy BUSHCHENKO, please. And I know you would be willing to use not English, right?
Я не знаю, если вы понимаете по-русски, мне легче говорить по-русски, поскольку в последнее время у меня мало практики в английском. Но если кто-то не понимает, я буду говорить медленнее, но по-английски, да. Можно по-русски, да? Ну, хорошо. Ну, как уже мои коллеги сказали, один из бенефициаров недавней реформы 2016 года, в результате этой реформы я вообще имел шанс попасть в Верховный суд, поскольку до этого процедура не позволяла не карьерному судье, а я не карьерный судья. Мы поменялись с Мykhailом ролями. Он бывший судья, теперь он представитель неправительственной организации, а я из неправительственной организации стал судьей. Я адвокат с более чем 20-летним стажем, и теперь вот занимаюсь судьей. Да, безусловно, у нас есть проблемы. И, возможно, многие из вас знают, что у нас сейчас уже принят закон, который предусматривает очередную реформу, что, на мой взгляд, ну, не очень хорошо. Я сейчас говорю не с точки зрения как бы судьи, которого это тоже коснется. уже сейчас касается. С точки зрения как бы объективного, стараюсь как бы немножко отстраниться от своих персональных там тревог и взглянуть на дело объективно. Мне кажется, что Украина пережила уже не одну реформу. Реформа 2010 года, ну это из недавних, реформа 2016 года. Вот реформа будет 19 или 20, как дело пойдет. Мне кажется, что это плохо, так коротко говоря, потому что такие частые реформы вообще ставят под сомнение независимость суда персе, то, что называется, поскольку судейский корпус никогда не уверен в том, что его гарантия, вот в частности гарантия несменяемости, будет соблюдаться, поскольку у нас каждый президент проводит реформу. То есть как бы кардинальное отличие судебной власти от выборной власти, оно стирается, поскольку мы как бы, судья должен переживать любых президентов и не очень обращать внимание на то, кто сейчас у власти. И, собственно, быть гарантией того, что кто бы ни был у власти, кто бы ни оказался сверху, все-таки гарантии законности, там, верховенства права, Конституция будут соблюдаться. У нас пока получается традиционно, что каждый президент проводит свою судебную реформу, которая, к сожалению, связана в том числе и со сменой судебного корпуса. Это было в 2016 году. Вот сейчас Верховный суд будет там каким-то образом проводиться селекция из самых лучших юристов, будут выбирать еще более лучших, не знаю по каким критериям. Что мне недостает? Я готов обсуждать, я могу очень много сказать о нашей системе правосудия, в том числе и очень много плохого. Я знаю эту систему более 25 лет, я в ней работал извне, так скажем, как адвокат. Сейчас я даже больше знаю, поскольку увидел, что там находится под капотом. И я очень много могу сказать. Я готов признать, что надо менять, и очень много менять, и очень много кардинально менять. Но просто вот, знаете, вот сегодняшний момент, когда вот такой, ну, на мой взгляд, откровенный наезд, будем говорить, на Верховный суд происходит, мне кажется, даже это накладывает на меня обязанности самоцензуры, потому что не хочу подливать, так скажем, масло в огонь критики, иногда необоснованной. Чего мне не хватает в наших реформах? Мне не хватает понимания, куда мы идем, вот чего мы хотим. Я понимаю реформу так. Это ж очень просто. Любой, кто занимался любым проектом, который направлен там, какое-то влияние оказать на внешнюю действительность, он говорит, вот такое состояние дел сейчас. Вот мы имеем сегодня вот это. А мы хотим иметь нечто другое. Рисует это другое, эту идеальную картинку, а потом придумывает, каким образом вот эту идеальную, наш идеал, то есть сначала обсуждается, хорош ли этот идеал вообще, всех ли он устраивает, вообще он отвечает каким-то представлениям, логике и так далее. А потом ищет путей, у нас путей, как добиться этого идеала. Я вот сегодня я не вижу. А для чего? Вот все время у меня вопрос во многих реформаторских устремлениях. Я там не могу сказать, что очень внимательно слежу за бурной деятельностью нашего нового парламента, но кое-что до меня доходит. Первый вопрос, который возникает, а для чего? Ну хорошо, давайте поменяем то на это, там, перекрасим, там, давайте мантии судьям поменяем, ну если говорить, давайте там их заставим, я не знаю, там в килтах ходить, может быть, что-нибудь такое. Вот вопрос, для чего? И вот эта слабость, откровенная слабость этой реформы и даже коммуникации по поводу этой реформы, потому что сказали, хорошо, много судей, 200 судей Верховного суда. В глубине души, да, я понимаю, это многовато. Это вся судебная система Армении по составу. Да, да. Это много. И это создает кучу проблем уже внутри самого Верховного суда и приводит к многим негативным последствиям. Ну хорошо, вы сказали, 200 много, 100 хорошо. Или там, ну, не больше 100, ну, 50. Почему не 20 там? Но вы не сказали, а что поменяется. Потому что 200 судей сегодняшних не успевают обрабатывать тот поток дел, который к ним приходит. У нас огромный бэклог в Верховном суде. Что делать с этим бэклогом? Поменялись процедуры? Вроде не поменялись. Ну, скажем, там что-то пытаются поменять в цивильной, там, в административной юрисдикции, в уголовной. Слава богу, пока ничего не трогают. Ну, я просто хочу понять. В 2 раза меньше судей будут работать в 2 раза медленнее, как бы, в совокупности. У нас дела, вот мы рассматриваем, некоторые дела там, рассматриваем решения там 17-го, 16-го года, апелляции. Понимаете? То есть уже мало кому интересно вообще исход его дела в Верховном суде, поскольку там уже кто отсидел, кто освободился, кто вообще потерял интерес, вообще жизнь поменялась. И ну, такое ощущение неприятное, когда ты решаешь дело, которое уже никому не интересно и никак не скажется на существующей действительности. Но сокращение приведет к тому, что эти дела, скажем, со сроком 3 года превратятся в срок в 6 лет. Это еще станет менее интересно. Я согласен с тем, что да, я могу сам придумать любую систему правосудия, я могу придумать систему, при которой и 9 судей Верховного суда будет достаточно. Но это другая система правосудия. И 100 судей Верховного суда будет достаточно. Но сначала давайте обсудим систему правосудия. И, что самое главное, задачи Верховного суда. Является ли это суд, который должен влиять на правовую систему в целом и создавать некие стандарты правосудия? Или это суд, как сейчас, который перемалывает дела по 3-му разу, решая фактически те вопросы, которые должны оставаться на первой инстанции и вообще не доходить до Верховного суда? Сегодня система такая. Под это сделали столько-то судей. Если вы хотите поменять систему и поставить другие задачи перед Верховным судом, давайте обсудим эту задачу, а потом решим, сколько для этого нам нужно человек. Еще что мне не нравится в нашей отечественной форме, я гораздо меньше знаю о том, что происходит у наших соседей в Грузии, в Молдове, но что у нас я знаю хорошо. И тут, может быть, мы давно были оппонентами с Мykhailом Жернаковым по этому поводу. Слишком большой фокус на личностях и слишком малый фокус на процедурах. Понимаете? Почему-то у нас есть убеждение, что можно отобрать какие-то волшебные, вот существуют какие-то волшебные люди, которые главное их туда внедрить в судебную систему, и ну, настанет счастье. Ну, во-первых, у нас мало вообще-то волшебных людей, если они вообще существуют в мире. Во-вторых, ну, должен быть опыт. Понимаете, у меня есть опыт сотрудничества, работы с разными людьми, и во многих случаях мне легче работать с людьми старой формации, там, ну, которые вот карьерные судьи, там они 30 лет судьей, я понимаю, что они там еще работали при советском там кодексе и так далее, у них свои фишки, свои представления, свои, как это у нас, забабоны. Да, с ними очень сложно, но мы с ними гораздо легче находим общий язык, чем со многими людьми, которые, ну, скажем так, новые лица. Новые лица, потому что у них нет того опыта работы в судебной системе. И они часто не улавливают каких-то особенностей чем отличается судебная система от научной деятельности или от общественной деятельности, или от, то есть, что ты принимаешь решение, которое может сказаться, особенно Верховный суд, не только на этом конкретном деле, но иметь далеко идущие последствия. И поэтому надо быть очень осторожным. И не каждую свою идею как бы можно воплотить в судебное решение. То есть тут очень много вопросов. Кроме того, я вам скажу, я же работал с Европейским судом и выигрывал много дел. И я много раз наказывал наш Верховный суд, тот, за их неправильные решения. И получается так, что они уже научены, понимаете? Они уже пуганые, так скажем. А пришли люди, которые не пуганы, и они не понимают, и они допускают те же самые ошибки, которые допускали те, которые уже поняли, что это ошибки. Новые люди, поскольку они считают себя новыми лицами со свежими мыслями, они идут по тем же граблям, то есть, ну, им недостаточно чужой опыт, им надо свои шишки набить. Понимаете, в результате во многих случаях происходит как бы откат назад. Понимаете? То, с чем ты работал много лет и вроде бы уже начал находить какой-то общий язык с судебной системой, происходит откат назад и приходится... Поэтому я еще раз говорю, это как бы частности какие-то, но вопрос в том, что не надо так сильно сосредоточиваться на людях, и надо больше вопрос процедурам уделять внимание.
Thank you very much, Your Honor. Thank you very much. I just, in this context, because we will switch to our neighboring countries, I would like just to pay attention to the very important point made during those two presentations. The number one, in each reform, it is very important to have vision, first of all, right? Where we're going, what is in the future, and what we would like to reach. Then the many people, majority of the people, they believe that the reform, any reform, judicial including, is changing the legislation. But no, colleagues, the changing legislation is only one stage of the reform undertaking. So first, a point I would say, this is a vision, what reform is or should be about. Then, of course, it's the legislative changes. And the third level or stage of any reform is the implementation stage. When the new law is in place, when the people who are affected by those new legislations, they should be trained, they should put in place new procedure, new policy, new everything to fulfill the law and to follow what actually was in mind when this reform was planned. So I just encourage our colleagues, Mr. Ilie CHIRTOACA from Moldova, please tell us whether your government had that vision, was doing as should be done, and it was not done in Ukraine, for example, right? Because still we have practicing lawyers and justices saying that, yes, we can increase or decrease the number of justices in the Supreme Court, but if there is no understanding, the right to fair trial prescribed by Article 6 of the European Convention is not to the top of the court system, it's only limited by appeal, and in exclusive cases it could be cassation, as we say in European dimension, cassation, right? So we will go nowhere, because if you start to limit a cassation procedure with a specific cases or specific parties, then there is a noise, oh, no, it's a limitation of human rights, it's a violation of human rights, we will go nowhere. And point number two is that when we're talking about judicial reform, it's absolutely inevitable to talk about rule of law. And what rule of law is about? It's about stability of the legislation. It's about predictability, right? It's about the certainty, legal certainty, when the people, not only judges, but ordinary citizens, they should know how to plan their behavior to be in line with what government is imposing. So I invite you, Mr. Ilie, to the...
Thank you very much. Thank you for the opportunity to be here and present the Moldovan example. If I may touch upon some of the points which were discussed earlier, of course, it is paramount to know where you are headed to. In case of Moldova, we have had a strategy, roadmap, let's to say, where we want to where we are now, where we want to be, and perhaps 2.5 years later, after this strategy expired, we can have some lessons and perhaps some points for thought. If to evaluate the progress of reforming the justice sector in Moldova, I will find no better description than the one that it was provided by the International Commission of Jurists back in 2019, well actually this year, when they visited Moldova and they had an interview with the judges and they assessed, they provided another assessment. And the title of the project, the title of the report says, "Just an Empty Shell. The undelivered promise to reform the justice sector." So just the empty shell, meaning that legislation is there. Many efforts were provided with the support of the international partners to have standards aligned with the best ever European and international practice. But what's missing is genuine and sincere implementation. To have these reforms in place. And don't get me wrong, because of this roadmap of the strategy, because of the EAP framework, we've managed to bring to have some results on the legislative level, on the technical level. We managed to secure the audio recordings of all the hearings. We managed to introduce a electronic system, random assignment of cases. What we didn't manage to change was to have merit-based selection and promotion of judges, because in more than 72%, those who came, the new candidates, the new judges which came into the system, were not the very best candidates who scored under their results at the National Institute of Justice, on their results before they evaluated some boards and some committees. The only one who decided who will pass and who will not was the High Judicial Council, the Superior Council of Magistracy. So we didn't manage to get their more dissenting voices and to have these checks and balances and a very representative Superior Council of Magistracy. As Mykhailo was mentioning earlier, yes, we respect the standards having the majority of judges, but if we look upon a closer look, you can see that among those judges, the ones who are influencing the process are actually the Supreme Court of Judges, which hold the majority of the majority. And they, but the architecture of the system is quite different. The majority of judges in Moldova are district judges. So you have 300 district judges and you have only 33 Supreme Court judges, but they are setting the policies. And we, as a legal think tank, monitor this selection and promotion of judges, and we have seen that, unfortunately, in the majority of cases, not the best candidates manage to get these positions. This is why perhaps we didn't manage to have a truly independent and strong and resilient judiciary. And the trust in the judiciary in Moldova is at incredible low. And this is both for the general population and for those who were interacting with the courts on the daily basis. According to a 2018 poll, more than 81%, both of those who interacted and general population, they don't trust the judiciary. And why this is happening? There are at least 4 reasons for which I can think about. First of all, the judiciary was involved in what we call today the Russian laundromat. More than $20 billion laundered through the Moldovan courts. there is still impunity and lack of accountability from the ones who participated and were involved in that. Second, Moldovan judges annulled the results of local election in Chisinau, which by accident were won by an opposition candidate. In 2019, the Constitutional Court judges, which are not from the judiciary but somehow are related, they forced the organization of snap elections. And last but not least, just recently, the mass media found a leaked document from the Supreme Court that the Chief Justice was having a table in Excel, very beautiful one, and with all the cases pending, and he was writing with a pencil the possible outcome for that decision. So these are 4 examples which they fueled the perception even more to the public that judiciary is not independent in Moldova. This is why with the beginning of the 2019, and I say that I would have to use the past tense already, the former government, which was sacked 2 days ago, they proposed a new reform to have the extraordinary evaluation of starting with the Supreme Court judges, and as in Ukraine, we from 33 we propose to have 17, but we believe that in case of Moldova this is necessary because we don't actually primarily need people from outside. We believe there is agents of change and critical mass in the judiciary, but for 5 or more years they didn't have the possibility to get to the Supreme Court. So this external evaluation or vetting, how they call it, entails that we will have cut in half the number of judges, but they will also be evaluated, the current one or the ones who want to get there, on 2 main criteria: professionalism and integrity. And we have a lot of issues with integrity, unfortunately, and we can have seen in the past some judgments and points of selective justice. Now, I don't know what will be the outcome of this reform, as the Venice Commission preliminarily assessed this draft law, and for me it is important that it said that in such critical situation as the case of the Republic of Moldova, critical measures are necessary. So this vetting is not actually a bad thing. However, we need to ensure more guarantees for those who are evaluated, meaning that they have a right to a fair trial, they have an independent tribunal or body who will assess if their evaluation, if they will fail the evaluation. And well, the government was sacked 2 days ago, and I just very much hope that the new government in place will be the same, as ambitious as it was the last one. And I would politely disagree with what my colleague said on the fact that we don't actually need people. Well, in case of Moldova, we do need the best of the best to choose them, or we need to give them such a feeling of the independence that they will want to come and work into the system. So for us, it's of paramount importance to get the best one served in the judiciary. And we very much hope that the new government in place will continue at least on the same path. I will happy to ask and answer question. Yeah.
Thank you very much. Thank you very much. It was interesting, and absolutely, I feel that maybe Moldova following the Ukrainian steps, undertaking back to 2016. You know, as a defense lawyer in my past professional career, I really have mixed feelings about what was going on and what's going to happen. But also, I would say, before passing the floor to our Georgian colleagues, I just would like all of us to think about whether there is a fault only judiciary or judges, the situation which is in our countries. You know, who adopted the law? Judiciary was self-governing in Ukraine since 1992. The result of that self-governance became that the law allowed to create qualification commissions, law adopted by the parliament, and consisting only of judges. And judges were employing, actually, they staffers, like assistants, secretaries, and they said, okay, circle is too narrow, let's go outside, let's go to family members. Son-in-law, daughter-in-law, father-in-law, mother-in-law. And trust me, and when we took a look, when we were undertaking this survey, because annually our program does twice a year, survey was public and also judges. And we asked those judges who participated, please indicate what was your past experience. And 78 current judicial corps, they have been judicial assistant, judicial secretary, or law enforcement, policeman. Tell me, please, what kind of decisions, of mentality, of freedom of legal mind you can expect having that composition of the judicial system. So my point is, I'm not saying that judges are innocent, no. But my point is that that was a member of the parliament who allowed them to be that way, right? So the government, I mean government in entire government, like a parliament and the government itself and judiciary, top-level judiciary, they should share responsibility for the state of affair in this system. So, but now we have been encouraged by Georgian experience when your very progressive president undertook, and one day he just fired all judges. Could you please, yes, it's our colleague from Georgia, Giorgi. CHITIDZE. Thank you.
Good afternoon, everyone. And first of all, thank you very much for having me here and giving me an opportunity to talk about the judiciary, especially in the context of association agreement. And although the title of this panel is to compare progress between Ukraine, Georgia, and Moldova, it will be extremely difficult for me to talk about any significant progress or significant achievements when we are talking about the Georgian judiciary. For example, last year we made an assessment of association agreement, how the state implements obligation under the association agreement, and one of the topic is of course the judiciary, and we saw that judiciary and obligations with regard to judiciary is very hard to implement, because reality in Georgia is that the judiciary have never been and still remains the least independent and the least trusted institution. So, for example, it was partially implemented, but for example, if you see the statistics, for example, 12 out of 14 activities which were created by judges themselves in their action plans have not been implemented for the last year. So it's very difficult to make any changes and progress even on the action plan level. Meanwhile, we went, for the last 7 years, we went through the waves, so-called waves of the reform. 3 waves of the reform, and the 4th one now is pending before the parliament. And by the way, this is the only reform which have been drafted by the full consensus among stakeholders, including CSOs. But unfortunately, I personally and my colleagues don't believe that it could change a lot in practice. And let me explain why, because at the end of the day we realize that we don't need waves, we need kind of tsunami to change really the system. And let me explain why, because there are 300 judges in Georgia, as already mentioned here, and 2/3 of them are already appointed for lifetime. On the one hand, lifetime appointment is not bad, so we were supporting this idea for many years, but as my colleague rightly mentioned, when the institution has no capacity to be independent, it has never been independent, when you appoint those judges for lifetime, it doesn't change a lot. So now, first instance and appellate courts are almost fully packed. With the current judges, there is no opportunity for new people to enter the system because it's almost closed. And on the other hand, we have the High Council of Justice with a super independence, constitutional status, but those people who have majority in the council show the clear signs of corporativism and cronyism. So they are making very controversial decisions, to just softly saying, controversial. They are controlling all the instances, first and second instance courts, because they are nominating and appointing their people as presidents and vice presidents of the courts, and those people are deciding how cases should be delivered, even though we implemented this electronic program, but still they have the power to take one case and to deliver it to another judge. So they're controlling the system, they are making decisions, and they are independent. And that's why no, they are the judges who were after this first packing in 2004, when Saakashvili dismissed all of them and brought new guys 20 years old and told them that you are now judge. And of course, and the only goal was to eradicate corruption, don't take bribes, and it worked. But afterwards, they were under the high influence of the government, of the ruling party, because the only thing they had an achievement in their life was the decision of the president to nominate them as judges because they were young and they were not taking bribes. So we are talking about those people. Now 2/3 of them, so majority of them, are appointed for a lifetime. So we have this situation on the first and second instance courts, but by the time as we speak now, there is a process of electing Supreme Court judges. So what happened is that the new constitution increased the number of Supreme Court judges from 16 to 28, and as far as we have only 8 sitting judges now in the Supreme Court, the ruling party got the opportunity to appoint 20 new justices, and the High Council of Justice got the mandate, thanks to Venice Commission. Unfortunately, I'm saying this, but it was not a good recommendation to allow the High Council of Justice to nominate, because before that it was the president who was nominating the Supreme Court justices. Now it's a High Council of Justice. And after exactly 1 week after the new constitution entered into force, without any procedures of appointment established in legislation, High Council of Justice proposed 10 candidates to the parliament. Exactly after the 1 week, the new constitution mandated the High Council of Justice to nominate judges. List consisted of judges notorious for channeling political influences within the judiciary and known as the clan by the civil society, because these are people who are making all the decisions within the system and within the High Council of Justice. But what's happened is that this attempt of court packing triggered backlash not only in civil society groups, but in the parliament as well. Some MPs even left the ruling party on this matter, and Parliament agreed to elaborate new procedures and new procedures of nomination and appointment. However, this window of opportunity, I can say, was not used constructively because the Parliament rushed the amendment to existing legislation that improves the process only superficially. So, disregarding the key recommendations of Venice Commission, OSCE, EU, Council of Europe, and US Embassy, even the Speaker of the Parliament said that the key recommendations that don't appoint all of 20 judges now was political in nature, and we are not going to take this recommendation because it's political. It doesn't have to do anything with legal matters. So, in result, at the first stage, High Council of Justice endorsed 20 candidates, and let me give a very clear example of who these people are and where I'm talking about the corporativism within the system. 15 sitting judges out of 20, 1 former judge, 2 high-ranking public officials, Chief Prosecutor and his deputy, which was an agreement between High Council of Justice and the ruling parties that these are my guys and they should be nominated, and 2 current or former judicial staff. So the list does not include defense lawyers, legal practitioners, or scholars. Going contrary to general recommendations that Georgia should open up the Supreme Court for different people because they should bring different perspectives as the highest instance of the court, because the Supreme Court tackle complicated legal matters from multiple angles, right? So But on the other hand, I really would like to emphasize that the committee hearings in the parliament was super transparent. It was a US-style hearings when all of those 20 candidates appeared before the parliament. MPs were asking questions. Our representatives, NGO representatives, were asking questions. Ombudsman's office was present there with a mandate to ask questions. Georgian Bar Association and Free Legal Aid Service. So at the parliamentary level, it was super nice. It was broadcasted by TV. And the only achievement now we have, and this day, because it's still pending, they should vote for these people very soon, till the end of this year, we got the publicity. And when those judges appeared before the public eye, it was a shock for society to realize that those people are deciding cases on a daily basis. Because people know ministries, know MPs, know political parties appearing on a daily basis on TV, never ever seen judges speaking publicly, right? And for example, many of judges even could not answer simplest questions, such as what is the rule of law? What regime was during Soviet Union? Is right to life absolute or not? And these kind of questions which are a part of the topics for students, for freshmen or second year students. I'm teaching in university. I believe freshman students know whether the right to life is absolute or not. And it's really worked. So now we are in the process of at least saving Supreme Court, because sitting judges, these 8 people, at least are not a part of this influential group. They quite often deliver different decisions than the lower instance courts. Now we do hope that if the parliament rightly chooses, like, I don't know, 3 or 4 people out of 20, because absolute majority of them do not satisfy criteria of integrity and qualification. It's absolute catastrophe what we've seen on a live year. Each day was dedicated to one candidate. So, for example, the head as Chief Justice of the Constitutional Court, who also wants to become a Chief Court Justice, he even did not recognize the excerpts of his own judgment. He told that it's written by Thomas Jefferson, maybe, because somebody read his judgment saying that who wrote that, and he replied, maybe Thomas Jefferson. No, Your Honor, it's you, it's your judgment. It means that he never ever delivered any judgment by his own. So to sum up, we have many similarities with our colleagues. We've gone through very many waves of reforms. We have super procedures on the paper. It's approved by many international stakeholders, but I can't agree with my colleague, with his honor, that the people are not problems. In Georgian context, yes, these people are the key problems of judicial, because they clearly saying, for example, the head of High Council of Justice said in last year that whatever rules and regulations you adopt, we are ready to adapt to it. So we will be ready to adapt to it, but they were not expecting so much publicity, and it was on our side. And the last sentence, our contribution in this process was to create, and it's a really good idea, I was personally involved in, to create individual portfolios for each candidate. We looked through their professional record, their behavior on social networks, their interviews, their articles, their finance and properties, which are really interesting because they are getting rich and nobody knows how. And we prepared and delivered to the parliaments, and it was extremely useful for MPs and other stakeholders because we created kind of real portfolio of the judge. Who is he or she who has the ambition to become a Chief Court, Supreme Court Justice? Thank you very much. If you have any questions, I'm ready to answer.
Okay, thank you very much. Colleagues, I appreciate it was absolutely wonderful. Each country has like unique experience, but we witnessing that we have a lot in common. And I believe that there's like a general problem for all post-Soviet states is the independent judiciary is not a value for politicians, those who are in power, those who are designing the reform. you know, so there is I like this expression, that the first, when you undertake any reform, you should keep in mind the first, number one, is a value. Is judicial independence value, is independent judiciary value for the democratic society or not? Then, if you accept, yes, it is a value, it is a relevant attitude. So you're taking care what the quality of the law should be, what kind of guarantee you should provide, what requirement to those who are pretending to occupy those positions should be in the law, because you care about the value. And then the third component is the democratic culture. And democratic culture, it's a very important moment when they're changing the government, when new president coming to the power, that they not review what was done before, but they following, they respecting, because in 5 or 4 years, the same next team will come and will review what you have done. So this is I believe this is a post-Soviet tragedy we're all experiencing, suffering from the lack of this value, democratic culture, and attitude as well. So with this, I open the floor for the questions. Please, you introduce to the 3-country the experience. It's similar and it's a different one. And please feel free to ask questions and address. And if there is a general nature questions, I make sure as a moderator that every speaker will have like 1 minute, 1.5 minutes to react and to respond. Thank you very much once again, colleagues. And please. No questions? Guys, so speak out, please. If you, yes, please. And also, identify yourself.
Just to break the ice.
Please. Thank you.
So I before you left with the conclusion that providing judicial independence to the justice system from the political, from the executive, is not the solution for the post-Soviet space. I would like to challenge you and share with us what do you think is the solution in this case.
Yeah, please, yes.
It's a very valid question, thank you. I'll start. Don't mind.
Just briefly, right?
Sure. No, don't take us wrong. I think judicial independence is of paramount importance. Thing is how to pave the road to that. By giving the unchecked, uncontrolled ways to do whatever you think should be done is not the way forward. That's what we learned. To let the system be self-controlled. I'll give you just one example. Maybe if the moderator allows me, maybe 30 seconds more. A judge comes to the qualification assessment, the procedure that we have now to check whether the judges are qualified for the job or not. Before the panel of the High Qualification Commission sit. Yeah. And she's asked, where did you get your, and she has, because we have all these registers open, thanks for the anti-corruption legislation and electronic declarations. She has a 400 plus square meter house, 5 apartments downtown Kyiv, and 2 land plots. And she's asked, where did you get this from? Because you couldn't have earned this. We see that you did not have legal income of that amount. And she says, as a student, I went to German Democratic Republic, East Germany, and picked up berries and did some other work. And they gave us free lunches. So I saved some Deutsche Mark and brought them back. And now I bought all this property. And all these panels, all these judges, elected by judges, according to all the European standards, say, oh, that's your green light. And then they write, there were no doubts about her integrity. And then she's elected by the majority of judges in the Congress of Judges to become the member of the High Council of Justice, to decide on other judges' integrity. Integrity is number one. So back in 2016, we decided that integrity and professionalism is paramount requirements and professional ethics for the judges constitutionally in Ukraine. So if we continue not only keeping these people in the positions, but giving actually them the highest positions in the, there will be no judicial independence. And then these people, being not independent themselves in the High Council of Justice, go after the independent judges. instead of actually protecting them and instead of cleansing the system. So we actually have it flipped, and some people even say, how it's not judicial self-governance, it's actually if you would give self-governance to organized crime, which unfortunately still big parts of Ukraine's judiciary are. So that's what we're talking about. So judicial independence, yes, it is important, but it's first important to secure that the judges are independent themselves and then give them self-governance. If that answers your questions, I'm sorry to be a little lengthy.
Yeah, thank you very much for this question. I frankly said I absolutely have no idea what can be a solution, but I can tell you what we've learned, what was the lessons learned in Georgia, that when the previous government decided to pack the court with loyal people, they end up in jail convicted by the same people. So, and the same will happen with this government, and every government who don't appreciate the value of independence of the court. Otherwise, without a political will, it will be impossible just to push for the independence. Whatever the guarantees you put in constitution or legislation, I absolutely agree with the moderator. You should realize the value. Now, the representatives of previous governments are complaining that what mistakes they made during the court packing. And the same will be with this government and every government which takes the same position. So this is a lesson, plus that society really saw who are these people in judiciary, and that's why if I have any hope that it will be improved and it will be better because of these lessons we learned for past like 15 years. Thank you.
I have no answer also. Yes, I have no. Really, I know the system very well, and
How do you manage your independence?
I don't know. My independence it's not due to our state that guarantee my independence. My independence is the source of my independence. That I'm a lawyer. I'm a good lawyer. Many people think so, and I understand that even I would be expelled from the judiciary, I will have some piece of bread in this life. So my independence, absolutely independent from the state. The state don't guarantee till now my independence. So the state is not guarantee for me. My independence is the source of my independence is outside of state security and so on and so on.
I don't have the perfect recipe, but I will agree that we should start with integrity in order to have an independent judiciary, because in Moldova we thought that if we give judges better salaries, if we give judges judicial assistant to assist them, if we give them independence of the law, overnight they will become independent, which is not the case. If, on the flip side, you start with selecting the best candidates who have the higher moral standards, the high professionalism, and then you enable them and give them better salaries, judicial assistance to better do their work. You give independence in the law, then you can secure that. So, in case of Moldova, I believe we have a lot of work to do to find the best candidate, best selection and promotion standards, not only in the law but also in practice, and to get rid of those who lack integrity. And those who lack integrity, for many times they send a signal downstairs. So if it's possible that a judge who evaluated her Porsche Cayenne for 500 euros in her assets declaration, and this is okay, you send a sign, this is okay, and this is not okay.
With your permission, I just would like also to react, to contribute to this absolutely amazing change of the minds. You know, for me, independence, it's a state of mind. State of mind. Every single judge, which who should have value, of course, right? An independent state of mind which allow him or her to decide the case according to the facts and to the law, and to resist. If someone calling you, please decide this case this way or another way, just to follow the law and to follow your belief, right? It's number one. Number two, all judges, I believe in all three our countries, maybe with very, very small exceptions, they believe the judicial independence, it's their privilege. But it is not. We know case law from European Court of Human Rights, and we know this European actual Commission for European Judges, this like opinions. As they say, judicial independence is given to guarantee everyone who's seeking justice the right to fair trial. It's not a guarantee for judge, him or her. It's a guarantee to those who are seeking justice. And with this understanding, I believe the only way, our young colleague asked, where is the way out? Training, and education of those judges who are not so corrupt. And one more issue, integrity. Our High Qualification Commission, when they started this like a qualification evaluation back to 2017, etc., they were fighting and they were struggling, suffering from the lack of the definition given in the law what integrity is about. And we were bringing different country judges, meet with them to explain them, etc. And I like one judge from Portugal, he said, the best guarantee of the integral behavior of a person in the future is his or her behavior in the past. So if you know this person as someone who was a lawyer or scholar or like law professor or even lawyer in the public service with integrity, with value, with number of staff, that is absolutely, of course, might be exception, but this person will be good judge. Okay, with this, please, I'm sorry, I took the time, please, sir. Yeah.
Yes, thank you very much. My name is Alvydas Medalinskas. I'm a political analyst from Lithuania, but who is now working for the last 5 years mainly with Donbas region, and also working with some Ukrainian NGO called Donbas Gate, which registered in Mariupol. So I know that when all discussions take place about judiciary reform or justice reform, whatever, mainly the subjects touches upon how this reform goes on the upper level. Let's say Supreme Court, Constitutional Court, if it's talking about justice system, prosecutor's office, and so on and so on. But in my activities, I faced quite a lot of various meetings and cases with the judges who are on the lower level. Let's say, for example, in Donbas. And of course, there is no such situation in Georgia and Moldova, where the part of the region is almost taken by Russia, and another part of Donbas, like the western side of Donbas, is still in the territory of Ukraine. And to my understanding, one of the first important things is for the another side of Donbas to show that there is a lot of Europe in this territory of Donbas and the control of Ukraine. A lot of Europe just means also properly functioning justice system. What I really think is lacking, and just my question, of course, we met with the Mykhailo ZHERNAKOV and the Chatham House discussion on the justice reform, it's an attitude in the regions. And to my understanding, don't you think that, of course, it's important that justice reforms, the judicial reform, talk about the upper level, but don't you think that maybe it's a time to come to the judges also on the lower level, because I'm not a jurist lawyer, I am the political analyst. They came to me, to my colleagues, and said, could you organize something, any meetings, and just could you help us to explain to the Kiev our ideas, what we think, how you feel, and so on and so on. And my question also to Moldovans and Georgians representative, what about your case? When you think about judicial system, do you also talking about how judicial system operates on the lower level of the system? Thank you very much.
Thank you. Oh, no, okay. Yeah, colleagues, please. Yeah. Okay, let's start from the Mr. Ilie. To be fair.
Yeah. Well,
part of the reforms which were announced in January were to bring on the one level more dissenting voices in this high judicial council, but also to bring more representation from the district judges, who are in fact the majority in the country, more than 300, but they get only 2 members in the Superior Council of Magistracy, while the Supreme Court judges, who are 33, they are getting 2 members, plus an ex officio member, which is the Chief Justice, and all of a sudden they will be the ones who vote on selection and promotion and so on and so forth. So indeed, there is need to empower for the district judges to become more vocal. And in this regard, I would also wanted to mention that there is a critical mass of judges within the district courts, which might be the next agents of change. But in the last years, everything was decided from the upside down, meaning even the training of the judges, whether it happened outside or at the National Institute of Judges, needed to be approved before to the Superior Council of Magistracy. So there was this control that you cannot attend a training which is organized by the Legal Resources Center if you don't have the okay from the Superior Council of Magistracy. And this is control from up down, and this is what we, with our efforts, we will try to get rid of.
About attitude. You know, I suggest that in Ukraine now the most problem for
Raise your voice. Even
Huh?
with mic, raise your voice. With mic,
sorry. I'm sorry. I'm sorry. I suggest the main problem is shortcut of judges on the lower level. So we have many courts without judges at all, and the overloading of judges. And as for me, I see I suggest that the work of district judges is the most complex in judicial system, the most complex. And I suggest that I try to be useful for district judges by providing them with some position that they may multiply or apply to a particular case, because I understand that they have no time to elaborate such a position, and it's my task. It's all what I may do to the law judge. Regrettably, our court, Supreme Court, is overloaded with some very simple cases, clone cases, and that just take our time and provide no use for the court system. But it's my task, and I try to convince my colleague to first to finish the case in Supreme Court if it's possible, and to provide legal position for the lower court. Clear legal position that all it's what they need from us, and consistent position, not one position in one case and another opposite position in another case.
First of all, thank you for this question, and I absolutely agree that judges on the lower courts, and especially in regions, are very important. But I can say, from our perspective, what is the roots of the problem, and it's a very simple and trivial. These people are afraid of losing jobs, because absolute majority of them are people who you never hire as a clerk in your private company. They have 500, 600 cases. Objectively, they don't have time to work on their professional life and career. But on the other hand, they have no background, and it was a problem in our education system back in 1990s when you can buy a diploma of a lawyer in every turn of the street. So that's a trivial problem. In numbers, they are in majority. They have the conference of judges, and they can make a huge influence on the decision of High Council of Justice because they are electing the members. But what they are doing, they are following all the rules from influential groups. Why? Because they really afraid of losing jobs. We had this experience. Before that, they were appointed for 10 years, and every single judge on the lower levels, especially, who became vocal, none of them were reappointed by the High Council of Justice, but they had this background and they are now attorney lawyers or working in private companies or are professors in universities because they were vocal, because they had such a background that tomorrow I will have some bread and I will have some job. In Georgia, most of judges are afraid of losing jobs. How trivial and how catastrophic it may not sound now. So.
Well, it's actually very good that I'm speaking after my colleagues. So just for you to not, I keep coming back to the same point, but just hear me out. What are the problems that we heard now? Understaffed. It's the decision of the High Qualification Commission of Judges, or the absence of the decision to announce timely the competitions to the local courts. Lose jobs. That would be, in the Ukrainian case, that would be a decision of the High Council of Justice to fire somebody or to apply any content and tradings, the decision of Supreme Council of Magistracy. No standards for transitional justice or whatever is very pertaining Donbass, partly parliament, but also judicial governance bodies. No security when it comes also on Donbass and in some other cities. That's the state judicial administration and also High Council of Justice, because judicial security service is also under their mandate. Whatever problem we have inside the judiciary almost exclusively has to do with judicial governance. That is why for us, yes, it is important to know certain problems and to also solve institutionally, procedurally, procedural codes, very important. But if we don't fix judicial governance, we can forget about the rest. We will never have independent and capable judiciary. That's my point. Thank you.
Yes, thank you, everyone. And just to continue what Mykhailo said, just a second. I was in touch like months ago with the head of the Council of Judges because we have been invited to contribute to the article by American colleagues regarding the justice delivery in the Donbass affected areas. And I contacted him and I said, I know that you have like a few meetings of the Council of Judges held in that regions. What kind of issues are they facing? Who could present this like a piece of information to contribute to the articles? And he said, I don't know. I said, but you had 3 meetings over there. Any minutes was taken, any issue were raised up, you have to address, etc. No. So what Mykhailo says, it's 100% true. So there is attitude, and those judges in the first level, they really neglected. I'm sorry to say this. Okay, more questions, please. Yes, please, sir. And this is
Thank you. My name is Matthias Nellis. I'm with the Center for Liberal Modernity, a Berlin-based think tank, and in the past I worked here in Ukraine, also, especially on anti-corruption. So I want to come back to the association agreement, because I think, Ilie, you were saying that it helped, at least from the outside, for the judicial reform. And so looking forward, do you think that the EU should address the problem of judicial self-governance in any future changes of the association agreement? So looking forward to the next 10 years, according to your experience, what should be in any changes of the association agreement that would enable you to improve the judicial reforms? Thank you.
Start then. There's literally 5 lines in the association agreement regarding judiciary. It is this thick, so DCFTA, of course, is the biggest part of it, but there's no concrete things, and that's the lack of concrete measures that the countries have to take is sometimes, or quite often, because we sometimes compare our governments to 5-year-olds. You don't hint at them. You don't go, make your judiciary independent. You go, eat your porridge then, or your veggies, then you can go and play. So in these terms, you have to, if you're EU, you have to speak to our government. Fix this in this and that particular way. The VLAP, Visa Liberalization Action Plan, was brilliant in that regard. It had very concrete steps. Introduce National Anti-Corruption Bureau with this and that. With such and such guarantees in such and such form. Yes, is it a little bit invasive? One might argue, what about our sovereignty? Well, get your GDP to a certain point, get your institutions right, get your everything, then you can have your sovereignty. Sovereignty is there to also, don't the EU countries deliberately give away their sovereignty for the intra-country institution for their own good? They do. So I don't see the problem here. What I'm saying is, yes, the very short answer to your question is yes, we would very much like very concrete answers, and really we think that the judicial governance is key, and actually including independent international experts for the time being of the reform in order to make it really independent and trustworthy is the key. At least our practice shows such. So thank you.
Okay. This question reminded me very old and good British proverb that you should not ask moon on the stick because nobody gives you moon on the stick. It's because when you're asking the EU to put some concrete things in this association agreement, there is no magic stick to give you some program how to achieve the independence of judiciary. And even though if they put some concrete steps, on the paper, once again, it looks like really good. For example, from 2012 till today, only USAID spent $45 million to strengthen the independence in Georgia. I'm not saying about the EU funds and Council of Europe. It goes like up to 100. For Georgia, it's a huge amount of money, but in practice, nothing changes. So what are you gonna ask the EU to deliver the moon on the stick? In our case, independence of judiciary. I don't see the association agreement such a leverage or instrument, because we have the European Convention on Human Rights. We have dozens of cases in Strasbourg, unfortunately lost cases, but within the system, you should decide. You should form your political will, and I don't see any kind of real instrument, as a real instrument, as association agreements to help us or to require us to make an independence of, or to guarantee independence of judiciary. Thank you.
Difficult question. I don't know. I don't know really what is the right way to guarantee the independence. I may indicate, now we have in our country very...
It was not about independence, it was about judicial self-governance, right?
And what the EU can do. What the EU can do.
With respect to
I'm sorry. I don't know. I'm not a participant of this self-governance body, but I would like to say something, maybe not popular, but our self-governance bodies, they have no more or less long period. They are not accustomed how to be self-governant, how to be independent, and how to be independent from the outside influence, from the parliament, from the president, from the, I don't know, prosecutor's office. They have no experience because of constant changes inside. Okay, we provide independence, but we are not happy how you practice this independence. The result of your choices, we are not happy with them, so we change you and try again. Maybe now we will be happy with the result of your decisions, and so on and so on. And the period of changes are shorter and shorter and shorter. I suggest that in several years we have every week change of some governance body, because the result of their decision are not attractive for us, for example.
Yeah. Just very quickly, the EU has been very active in conditioning that you can receive our support pending the fact that you will deliver real reforms in the justice sector. In 2017, following the fact that nothing happened towards the reform of the judiciary, the EU decided not to transfer any funds to the Moldovan state budget to support the justice sector. A year later, it has put on hold the macro-financial assistance pending tangible results in the justice sector. And they have resumed it in 2019, and we don't know if they will continue to do so, but the EU and this framework of the Eastern Partnership and the framework of the association agreement plays a crucial role, because when they meet either in Brussels or in Moldova, we have to say that how we are going towards implementing the association agenda. And if you don't have tangible results, then the support of the EU will be put on hold. And this exchange rate, you do reforms, we support you, is necessary for Moldova, considering that the budget austerity and the EU money is important for the country to develop and have conditions to the social, like cultural, like the state budget. Thank you.
Cake and stick. Yeah, please.
Thank you very much. I really enjoyed the discussion, and the depth of the discussion, and also the comparative perspective. I think it's really very interesting to look at. But still, as I understand, I mean, I don't really can you? I want to understand whether we really can see a model, a vision. I mean, Arkadiy thesis that there is not. I mean, first of all, and Nataliya has also said that first of all there should be the vision, how to get there. What's the ideal state of judiciary, how to get there? So, okay, I mean, theoretically speaking, Nataliya presented some parts of it. The problem is, I understand, is really how to realistically to get there, and what is the model which can inspire us. Just for, I think that many people in Ukraine, if we would be talking here, like, I don't know, some years ago, would say that Georgia is a kind of brilliant model of inspiration for reforms and everything. Now we hear that Georgian case is actually maybe not that shiny as well. And so where can we look at, is there any model to be inspired of judiciary reform? I mean, for instance, we hear that in the Western Balkans, who are on the way to the EU membership and so on, kind of things are moving better, but frankly speaking, recently I heard that from some experts on Western Balkans that actually there are also many disappointments, specifically in the rule of law area as well, and especially also about judiciary, about some cases and so on. So I know that European Union, it's really, I mean, it's judiciary is high on our agenda, and we just heard in this morning that all this stuff about economic development and integration is also very much dependent on perception of the rule of law, state of the rule of law in Ukraine. And the European Union is very, very interesting. They don't have acquis communautaire in the field of judiciary. That's why the association agreement is such kind of short and vague about it. But at the same time, they apply, for instance, this EU Justice Scoreboard. A lot of benchmarks assessing member states. I know that now this same exercise they started to do for Western Balkans. Now there are talks maybe to do the same thing for our countries here. Somehow they don't have EU money for that. They want to have it from World Bank. I don't know why, but okay. Anyway, the thing is, do you think of some model models, maybe countries where you would say that reforms have been successful in recent, I don't know, years, and of course, better if it would be comparable. Maybe, I don't know, other countries like Poland or who exited the European Union before, or others. I don't know, just, I mean, where is that model on which we can borrow? Thank you.
Thank you very much and for this wonderful question. And please, Ilie, we keep our tradition.
Well, I don't know if there's a definite, clear-cut model in one country, perhaps maybe more country. I don't have, honestly, an answer. I just hope that we can manage at some point to have it so high on the agenda and so popular so every ordinary citizen will think that this is necessary. Speaking of Albania, as far as I heard, when they adopted the constitutional amendments and they decided to reform entirely the judiciary, they had 90% public support. And people, after they voted this in the parliament, they went marching down the street like after a football game match when you won. So perhaps these are the starting point, to have it more and more people understand what is the core of the problem. And I'm happy that in this regard, if 7 or 10 years ago nobody knew what is the High Judicial Council or Superior Council of Magistracy, at least now people talk about it. I truly believe we can borrow from Albania, we can borrow from Estonia, maybe from established democracies, or and considering maybe the lesson learned in Georgia on how to do it. But unfortunately, well, I don't have the knowledge of some ideal country or model which can serve as a blueprint for us.
Не знаю, ну, если брать за образец, Великобритания, где судья совершенно спокойно может облокотиться на правительство, и ему ничего за это не будет. Он абсолютно в этом уверен. Это не говорит о том, что там они все выносят правильные решения. Да. Может быть, нам королеву надо, что неплохо было бы. Да. То есть, понимаете, вот когда мне говорят о том, что у нас судьи должны быть независимые, я пытаюсь всегда спросить, а что вы понимаете под независимостью судьи? На самом деле правильных ответов почти никто не дает. А независимый судья — это когда он выносит решение, которое никому не нравится, и вы с этим ничего не можете сделать, понимаете? Против него не начинаются гонения, там, его не увольняют с работы, ему не обрезают зарплату.
Если оно не нравится никому, то где же общественная поддержка независимости власти? Кто заинтересован в независимости?
Дело в том, что, понимаете, судья стоит в очень сложной позиции. Часто он выступает против общественного мнения. Когда все кричат «ату его, ату», он встает, и он единственный человек, который вот этого гонимого может защитить, понимаете? И, как правило, именно вот эти решения входят в историю, которые приняты против общественного мнения. Понимаете? Потому что они обоснованы, судья прекрасно понимает, что он идет против общественного мнения, естественно, он обосновывает, почему он так делает и так далее. Ну, смелость, понятно, ну, вы понимаете, нельзя требовать от 8, там, или сколько сейчас, там уже не 8 было, 8 тысяч судей, в Украине сейчас там 5, нельзя требовать от 5000 человек, чтобы они шли на работу как на амбразуру, понимаете, то есть он должен хотя бы чувствовать, что его там не застрелят, не уволят, не обольют там зеленкой или там, не бросят в него гранату, или не побьют битами на выходе из суда. Это задача государства. А решение может быть очень непопулярным, крайне непопулярным. И это задача государства — защитить такого судью, даже если и государству не нравится. Мы вот все время говорим о том, что наши судьи находятся под влиянием там, прокуратуры, там, госорганов и так далее. Это не совсем правда, потому что прокуратура и госорганы, они отражают, и парламент отражает общественное мнение. Это как увеличительное стекло, они просто фокусируют это общественное мнение, понимаете? То есть судьи находятся под влиянием, в конце концов, общественного мнения. И независимость определяется способностью противостоять этому общественному мнению.
So, shortly saying, the difficulties with the copy-pasting models or creating models is that judiciary is really different from other branches of the government. When we were talking about the Georgian reforms, Georgia were successful when the vertical decisions were made and the one political party had a majority and everything was happening fast. But with regard to judiciary, we failed, and it's clear. Because in judiciary, it's the most difficult thing to ensure independence of a single judge. Because a single judge decides the case at the end of the day, and there is no vertical system like in the prosecutor's office, in other offices. So I frankly saying that I don't believe in any ready-made recipes or models to bring some judges from abroad or just to change everything, you know, because you should understand what you want, and everyone, of course, everyone realizes we want the independence of the courts and judiciary, but at the end of the day, nobody, no political parties, either in opposition or in the ruling party, don't want to ensure the independence because they see the threat in independent judge, in a single judge. That's the problem and not the model, which model should be copied from Albania or from UK or from the US. But you can integrate some elements, of course. For example, US-style committee hearings in the parliament worked recently in Georgia. You can integrate some elements, but I don't believe to copy-paste these systems because it doesn't work.
It's a very good question. Is there a one-size-fits-all approach? I absolutely agree here that none, there's none. Natalia mentioned the work by two Czech experts, Michal Bobek and David Kosar, Global Solutions, Local Damages. It specifically targets Central Eastern European countries when they were applying this majority of judges elected by judges rule, where the Western Europe came to Eastern Europe and Central Europe said, look, there's this magic called judicial councils where there's self-governance. Do so and you'll be fantastic. Didn't happen. They say it ranged from dubious to outright disastrous, the results of this application. We had similar problems in all the three countries, what it looks like at least. So one-size-fits-all approach, no. But what can borrow jurisdictions, bring in judges from other countries or outsource your to some other courts? Well, there were courts in Sierra Leone or other countries who spent $2 million daily for the operation of this court because you had to establish the secure institution, the secure building, premises, and then the energy plant specifically to power it because there was no energy plant that would be powerful enough to power such a building. Also, very mixed results. What you can borrow though is import integrity actually for time being. If integrity is our concern, and I think this is the case, then you can import best practices, then you can import people who would do this HR job for you, because hiring judges is basically an HR job from a business perspective. What do corporations do when they see the problem with the HR? Because of the conflict, they outsource it. They hire a company. And this is, what you're asking for a country it's not very humble to say so, but I say Ukraine. Take a look at the anti-corruption court. I started with it, and if you allow me, I'll finish with it. Did it attract the magic people from the moon or Mars? No, but it managed to select pretty much the best, or very close to the best, out of who applied. At least we did not select obviously people or judges who lacked integrity unconstitutionally. We did not do that because there were people capable of doing so in the panels who we asked our partners, the EU, the Council of Europe and others, to delegate. And that worked. I think, I don't know very much the example of Albania, but I think we're very much looking forward to the reports from there, but from what we're seeing and people cheering and all that, that was a good policy move. So no, you can't. And of course, it's a generational change. Before we get these magic people who would really be there, who would be perfect lawyers and very close to perfect at least, who would deliver the best judgments, some years will pass because it has to do with trainings, with culture, with many other things. But we can get as close to the best we can do right now with the help of the international experts, and at least not do this black magic with all these appointing these very, very strange people to the highest judicial institutions that we're doing now. Thank you very much.
Thank you very much, colleagues. And so we're approaching time allocated for our session. I don't think that we should abuse the agenda, but if I allow it, just also to share my vision regarding the metro question. You know, I always say the irony of my professional career in that I gave up my law practice not to be in the court, not to see judges. But the last 12 years of my life, I'm spending working with the judiciary, of course from different sides, working this judiciary to become better. And when I'm asking myself, what kind of model, right? Because I was really giving some time and some thoughts to this idea. I would think that it should be very simply organized structure. It should be judges at first level, 45+ years, with a life and professional experience, who know how life is going, and they mature enough to resolve the case. I would like our country to have the well-developed alternative dispute resolution system where people fostering the social trust, happiness, and not fostering enemies, losing cases in the court and not fulfilling and not enforcing the decisions. And on the top of the system, I would see like 9 justices of the Supreme Court, not 200. Because honestly speaking, of course, with all respect to all those 193 justices, it's well-respected, decent people now there. But, you know, this is the attitude. Remember, we were talking about value, attitude. And when the lawmakers fixing the 200 people in the Supreme Court, it's how to say, it's giving less value. Because when you have 10 or 12, it's okay. It's totally different story. And you can choose from the entire 42 million country, like 12, the most decent, the most professional. And it should not be limitation by 65. Because if we start at 45+, it should be like in US, right? Until you have healthy mind and you manage yourself properly. So I, again, thank you very much for your attention. All audience, I appreciate that you gave priority to this session, attended it, and I just absolutely appreciate everyone speaker. I had the honor to moderate to this session. And I just would say that, you know, we don't need like a common happiness, but we need justice. And justice has to be done. And everyone should see how justice is done. So with this, I would like to conclude this session. Again, thank you very much, and I hope in the future we will. Thank you.